Yes.
Lordship, with the consent of the other side, I beg to mention item number 17 of the today's daily list.
17.
Lordship. Lordship, may agenda matter for this week. For a week. Lordship. My senior is out of station. Lordship.
What is the matter?
My matter is about dismissal from service. Lordship.
Huh?
Dismissal of the petitioner from service. After
Okay.
a week. Lordship.
List this matter after 3 weeks as prayed provider learning council.
Offline.
May it please your lordship. I beg to mention item number 5. The subject of the other. Maybe attend for the maybe attend.
You are for petitioner? As prayed provider learning council for the petitioner, list this matter after 3 weeks.
Offline.
In which case we have ordered for personal appearance, by which order?
Your lordship directed personal appearance in item, my lord, 404, my lord.
Item 14.
My lord. But the personal appearance, my lord, has been shown in the contempt
That's
cases.
why, because
Yes.
not in contempt, it is in the writ petition.
It is in the writ petition. But before your lordship takes up the matter, my lord, I want to give a short, my lord, view of what has
No,
happened.
just we want to ask the person concerned. We are not, we do not like to call responsible officers to the courts. This is, let us make it clear. But if an issue cannot be resolved for absence of the lawyer day after day, then we are compelled to ask the person concerned to explain.
Correct.
We do not know under what, if the lawyers are also having the same situation as the employees, definitely lawyer will not appear. Isn't it?
Correct. My lord, before your lordship interacts, my lord, with the officer, my lord, Mr. B.K. Agarwal, who is presently the additional, my lord, registrar of the cooperative society, as well as, my lord, he is the chief executive director of the Escort Bank.
Okay, before you proceed, so that's why, Mr. Agarwal, we have called you. We are not happy to keep you standing here, but we are compelled to do that because of who will now represent Escort Bank. We want to know that. Who is your counsel? Yes?
I will represent. I am sorry for the last date, 1 day.
No,
because
we will not accept this kind of behavior, number one. And number two, if you have any problem with your client, withdraw your brief. Otherwise, we'll refer it to bar council. We'll treat it to be a misconduct.
in fact,
Be clear on that.
all the dates that I am appearing.
No, understand, but
Yes.
one date
Yes,
may
no,
be also
difficulty
problematic.
because
These
I-
are serious issues. Supreme Court has passed the order. Employees are not being paid. That is not the way.
I will let you know.
Better be careful.
I am
Okay, so what we could understand is that there is a proposal for revival, something like that, for which the bank is to give up concrete proposal, in a sense, a feasibility report that if we go by this way, this can be revived. We cannot direct that on the giving of bank will issue a writ of mandamus to revive. That will again depend upon the state, because it's a proposal. State has said that you give us a proposal. Not even only the co-person department, finance will involve.
Correct.
But what we have seen is at the one part, there are clear direction from this court to pay the salaries, etc. to the persons. There are direction even from Honorable Apex Court, and these are being not implemented.
Correct.
On
Serious,
this ground or
Serious.
that ground.
Serious, ma'am.
Okay. So you you just say us,
Yes.
we will accommodate you.
Today I'll present, very shortly I'll apprise.
Yes.
Before that, if your lordship comes to the order passed by your lordship on 5/1/24,
Yes.
my lord, last part is relevant And this, my lord, observation, which has been, my lord, submitted by the, my lord, in fact, the council
Name of finance
may
is
not-
shown.
may not be correct. Name of finance, my lord, is perhaps not shown. But on the last occasion, finance department, my lord, has appeared.
Huh.
My lord, I read out the last part,
Hmm.
but the
Hey,
penultimate paragraph from the materials and,
just a minute. Borpuzar. So that,
may I start, my lord?
yes.
Your lordship will take up the penultimate paragraph
Hmm.
of 5/1/24 order.
Hmm.
From the materials and affidavit file, it is seen that the finance department has taken a stand that even the government is willing to make a plan for revival of the bank, subject to acceptable and feasible proposal for revival of the bank is made by the corporation department to the finance department.
Hmm.
However, such proposal has not yet been submitted by the corporation department.
That is the submission
lord,
made by
yes.
Borpuzar.
My lord, this is not correct because it's contrary to the record.
Hmm.
I hand over these letters, my lord, to your lordship, my lord,
Hmm.
where your lordship will find in 2021 itself, my lord, the proposal was sent.
Hmm.
Thereafter, my lord, by way of a cabinet memorandum,
Hmm.
this, my lord, proposal were adopted
Hmm.
and it was sent, my lord, to the finance department.
Hmm.
Now, what the finance department says that due to pendency of these two writ petitions, my lord, 404 and 1086, my lord,
Hmm.
the finance department is not in a position to take the decision with regard to release of the amount. What the finance department will do,
Hmm.
my lord, the impediment has come due to the pendency. My lord, this is what
Very
the
well.
finance department says.
Very well.
Yes.
Let us
Second
take
video
it.
also.
Okay.
My lord, what I propose,
Hmm.
since there are clear directions, my lord, of the Honorable Supreme Court as well as this Honorable Court,
Hmm.
your lordship will say either way, my lord.
Hmm.
Your lordship can dispose it off, or your lordship can say that pendency of these two writ petition will not, my lord, come as a hindrance
Hmm.
for the finance department to immediately take up a decision. Whether the money would be released, my lord, or if it is not in a position, then the, my lord, the corporation department will go for liquidation, my lord. These are the two options available. My lord.
Yes, that is what we have expressed.
Yes.
If you cannot go for liquidation,
Exactly.
pay the person's
Yes.
money from the liquidation proceeding.
Your lordship will
We
take up.
cannot direct for revival.
Yes.
We cannot issue a writ of mandam.
Your lordship will take up the last letter, 7 October 21. This is, my lord, the
It
issue
will
by.
be a better, we'll make an observation.
Hello.
Just we want to have finance department today itself, here, it may take up after some time.
My lord.
After some time. Okay, so this is one aspect, you show it to him.
My lord.
And for our proper direction, file a short affidavit, bring it on record, this document.
This part.
Yes.
Correct, my lord. That would be more convenient for your lordship.
So,
my lord.
so on the basis of that, we'll record it
Yes.
and will not dispose it off.
Yes, lordship will keep it pending.
Because we are concerned about the employees.
Yes.
Whether revival is there or not there, we want our orders, Supreme Court's orders to be implemented.
Implemented, correct.
May I also point out, if it eventually comes to liquidation,
Hmm.
the bank may perhaps also the corporation department at least file an affidavit disclosing the assets of the bank.
No, it's not at this stage.
Yes,
Why are you
but-
now going for
That
liquidation?
will-
They are
if
saying
it
we want to
eventually comes to
have a
that,
revival. This is the
Yes.
proposal. Why should we need
That's
to
the
have?
letter part.
That is a
let us
letter
say-
part when it fails.
That's my lord team.
Okay, don't be negative.
This is only a
Be
tentative view.
positive.
Because we've been at the receiving end of it, but it never happened. Let's see.
See, let us see.
We are also trying, my lord.
Yes, yes. Don't take it as an adversarial little, and you be here, huh? Mr. Talukdar, you personally.
Yeah, I'll be personally present. My lord, only I request your lordship, my lord.
Ultimately, the bank's council is having no role as on that.
Correct, correct. It's the finance and corporation eventually.
Yes, eventually it is the government now.
Come. My
Okay,
lord,
even it goes on liquidation, then also bank's council is not having
Yes,
any role.
Yes, any role, correct. My lord, what I pray, lordship will, my lord, in fact, tag the writ petitions as well as the contempt.
Yes,
Because
we'll do.
otherwise there would be two orders
No,
in
no,
two different
we'll
proceedings, my lord.
do it. If
Yes.
we are not passing any order right now on the contempt, but we'll get the response from the finance department. We'll wait for some time,
Yes,
we'll
correct.
keep it as a parrot. If it is possible that they are starting from revival.
Yes.
Revival will definitely mean the finance will take note of the
Yes, correct.
implementation of court's order. We are
Correct.
not saying that other things.
Right.
Other things, there may be packages, something like that we cannot comment. But so far implementation of this court's order, we can definitely say that it should be included.
Yes, correct.
Isn't it?
Correct.
So let us wait for some time.
Well,
Let Mr. Borpujari come.
Well.
And we'll specifically, you and Borpujari be here
Yes,
We'll
correct.
keep it
Lordship
as a
will
part.
record it, fine. Obliged.
and file a short affidavit.
I'll file it.
He may go. Mr. What is his name? Just
Hello.
record his name, we will dispense it his personal appearance for the time.
This Vinod Kumar Agarwal, my
Vigat
lord,
Kumar Agarwal.
additional register of
Register Reserve Cooperative Societies.
as well as
Come,
executive
Chief
director.
Executive Director of
Yes,
the bank is present pursuant to this court's order. So, just keep it, then we'll pass the, he can
His presence is dispensed with.
dispense.
Oblige.
It গোটেই series তলত পিছত তাৰমানে মই তোমাক দেখাই দিছো 6 7 8 9 10 ইফালে হেডিঙত 14 15 16
Lordship, I'm appealing for a petition of petition.
yes
Lordship, there's some buy order, I just please don't need any match. I don't matrimony passes her to timely.
why
Senior is in license for 26.
no that let us see what kind of contempt or what is the case about
Contempt case?
contempt or what
No, read petition, my
oh
lord.
writ petition with IA
Yes.
yes
Lordship,
Mutari why this matter is listed
Mali mention for any sir, okay? Buy order. Some issue as regards service, your lordship.
but there is a stay order
Yes, operating as on date, my lord.
who is respondent number 3
We are responding number 3 and 4, madam. Director Tata Memorial Hospital, Mumbai.
who filed this IA
They have filed that. People who are
IA,
cancer institute.
4215 of 19 has been filed by us, madam.
what is this application
So vacation of the interim order, madam.
and what about 6540 6504
504.
yes you want to press the IA
No, my lord.
you
let
don't
my
want to
senior
press
come.
don't want the interim order to be vacated
My lord, I have no answer to your question. Kindly,
Lordship,
senior,
since the matter relating to selection,
therefore
Yes.
since it's a big cancer institute
yes,
so therefore we want to decide this matter at
yes,
the earliest
yes.
either because see it's a institution of public interest then there are some technical persons
My lord.
if you get if you do not get then others get
Well,
number one number two is interim order will help nobody
no, what happened, your lordship? After interim order has been passed, they violated the court's order and gave a point.
so if these persons are already appointed
Yes, according to my instruction, they have been appointed. Lordship,
Okay.
Till then, Lordship, we pray matter will be taken up on a short date, my lord.
you want to
Finally
file any
decided, sir.
affidavit
There's some-
yes Mr. Doctor
Short date of-
So in this case, the lot will find
there is a stay order
2019
that's why we want to also take up this matter when tell us
and 3 posts your lordship has seen.
Hmm.
They could not be accommodated. And it's a
Lordship, according to my
No,
information.
whatsoever, whether they have appointed or not appointed, that can be a contempt or something like that.
No,
is
we already
different.
preferred contempt,
Huh?
already preferred. contempt.
Okay. So let us decide this.
Yes,
Selection
madam.
should not be stalled.
Lord, can it be done as early as possible?
So you agree on it.
What is happening because of the shortage of staff, as your lordship understands, the cancer institute.
That's exactly that you have expressed.
And
Whosoever gets, we want some people, efficient people, qualified people to be in the hospital.
the most affected department is the radiology.
Hmm.
And the radiotherapy treatment is delayed
When
by
tell us, such Saturday.
Saturday.
March, first week of Saturday.
Why you want to suffer this institution?
Saturday, we are, at best, my lord, you lordship can see the, who are the sufferer, cancer
No,
patient.
no, forget about that. That we understand. When? Saturday.
This Saturday, I am ready.
Saturday is a good day.
17.
Day after tomorrow. At least this matter
Lordship,
day after
lordship,
tomorrow.
can it be first week of March? Any date, any
Then,
short date.
then let them proceed with the selection. We'll,
So selection is all over.
My
no,
lord,
no,
you've
let them
appointed-
appoint.
Already appointed.
Subject to outcome of this writ petition.
3%, sir.
Lordship, for any date in the first week of March, any date, convent to your lordship.
First week is difficult. Saturday is a very free day.
Lordship.
That's
Ah.
the reason
Maybe
I was proposing that day. Because we are all-
Saturday we have not fixed any, but March it will be difficult.
After May, March, huh?
Before 11 March, no possibility.
17th tomorrow.
After March.
No. 17th February, I'm telling. 17th to
Tomorrow.
শনিবার আরম্ভ করুন।
পরোকি।
Oh.
না,
She wants
No want to come.
to take rest.
No, she is having responsibility. She is a senior.
Yes,
student.
Not sure.
Yes.
Yes.
Stay after tomorrow.
Oblige.
Yes, Bapujari. Now your stand is controverted. Seriously controverted. Give the copy.
মানে মই তোমাক দেখা দিওঁ এই অৰ্ডাৰ
Because we have recorded that government is ready, there is no proposal. So that we have recorded on last occasion on your submission. Anyway, that might be your instruction. Let us not go to all these disputes. Now he brings her, where is that? Give him the. Now he brings certain document which says that even proposal is accepted, now only the initiation.
My lord, that is with regard to item number 14 and 15. 14 and
14 and 15 only we have recorded. We want your assistance in 14 and
No, no,
15.
my lord, I have left both 17 midway and hurriedly.
No, we have not said midway. We say that we'll wait for Mr. Bapujari.
Now, my
No
lord,
problem.
Now, my lord, the submissions which I have made,
Hmm.
that finance department has nothing to do unless and until a proposal is forthcoming from the corporation.
That was we have recorded.
My lord, it is based on the affidavit filed by the finance department.
Ah.
Now, my lord, if.
Now we say that it was, that's why we have recorded on affidavit. Now there might be after affidavit, there is a change of situation. So this has come. Now don't take it as an.
I humbly pray,
Hmm.
my lord, let these aspects of the matter be brought, my lord.
No,
by
that we
way
have
of-
already, we
by
have,
way of an affidavit, so that, my lord,
just we wanted your presence.
Presence.
That we have already, okay? So we'll say that though it was a stand in the affidavit, however, in the meantime, this has been done. Mr. Talukdar will bring it on by way of an record. In the meantime, Mr. Bapujari will address this court on the up-to-date status. In as much as this court is concerned about non-implementation many orders under which directions were issued to make payment of their salaries and statutory dues. Isn't it?
my lord, once the affidavit is filed, my lord, I will seek instruction on the strength of
Before-
that affidavit. My lord,
correct
I do not know, my lord, what materials they will be
No.
putting before the court. So, my lord.
Okay,
let me-
but
let me-
Talukdar, when can you file?
I'll file within a short date, মানে 7-10 days মানে
You write this order in item number 14. 14. Rest will follow. Jahan, rest will follow. We'll look into all these matters later. Which order, Mr. Bothak?
order dated my lord last order
5-1.
my lord 5-1
Pursuant to heard Mr. S.K. Talukdar, heard Mr. B. Chaudhuri as Zahan, and who are they? J. Paul G. Bora for the Learned Council for the petitioners. Also heard Mr. Talukdar, S.K. Talukdar,
Cooperation Department.
Cooperation, Learned Standing Council Cooperation Department. Mr. R. Bapujari, Learned Standing Council for the Finance Department, and Mr. A.U. Ahmed for escarpment. Full stop. At the outset, Mr. Also Mr. Agarwal, what was the name?
BK.
BK Agarwal, Swencho is present pursuant to this court's order dated Swencho. Full stop. Mr. A.U. Ahmed, Learned Counsel representing the Escart Bank submits that uh, why you were not present on that day? Anyway, we are not saying anything. Okay. Okay. The personal appearance of Mr. Agarwal is dispensed. Referring to this court's order dated 5/1/2024, Mr. Talukdar has submitted that pursuant to the earlier affidavit file. Okay. Okay, file, comma. The executive director of the bank, chief executive director of the bank has already submitted a revival proposal of the Escart Bank based on what is NAPCON's,
NAPCON, my lord, it's a wing of the NABARD, my lord.
okay,
Consultancy of the
based on NAPCON's, NABCONS feasibility report study, based on NAPCON's feasibility study of revival of the Escart Bank. It is stated that NAPCONS is a consultancy firm under the NABARD. Full stop. In this regard, the communication dated 2/9/2021 addressed to the secretary to the government of Assam cooperation department by the chief executive director is produced by Mr. S.K. Talukdar. A copy of the resolution of the board of directors dated 1/9/2021 is also forwarded, also submitted, is also produced by Mr. S.K. Talukdar. Mr. Talukdar has also produced a cabinet memorandum for the revival of the bank and the proposal thereof. Full stop. Mr. Talukdar has also produced a communication from the Deputy Secretary to the Government of Assam Cooperation Department addressed to the Register of Cooperative Societies Assam and to the Chief Executive Director Escart Bank as regards the draft cabinet memorandum and requesting further follow-up in this regard. In view of the aforesaid development, Mr. Barpujari, Learned Counsel for the Finance Department, submits that, before that, this court thinks it proper that such documents and stand of the Cooperation Department should be brought on record by way of an affidavit. Full stop. Accordingly, list this matter on. Give a date.
Lord, we'll give it 10 days time. Lord. 10 days time.
Give a date.
I'm only asking for 10 days time.
Give a date. You propose a date. That's all.
Lord, we can fix it on 28, my lord.
28 of
Okay.
February 2020.
My learned friend have some inconvenience. Lord. 27? 27? 27?
No hearing date is required. We will not hear or anybody will submit any case.
27 then my
27th?
27.
27th of February 2024. Full stop. The regarding the non-implementation of the earlier order of this court as well as of the Honorable Apex Court as regards payment of dues to the ex-employees of the Escort Bank shall be considered on the next date fixed in as much as in advancement, revival of the bank may lead to implementation of the aforesaid order as well as reinstatement, payment of such as well as reinstatement. Okay. List this matter, list this matter accordingly on so and so as part heard. এগুলো সব একেলগে করে দিব।
Along with item 6 to 11, my lord.
And what will you do is, I have marked these cases. First order will be this, list this matter along with so and so. So this will be the first case, lead case, okay?
Other.
If not, my lord, can I have those papers back, my lord?
Yes,
I'll put it on affidavit.
yes, yes. Jota, কোনো কথা নেই। Any importance,
No, no,
whether it will come in orders or
No.
hearing?
Lordship, the keys of the matter. I will also try my own.
Because there are another aspect, we are not recording. This is a proposal of 2021. Time, there may be some reconsideration, something may
Correct,
be
correct.
necessary because,
Therefore, my lord, once they.
and now the budget is over.
Yes.
Again, it will take 1 year
One.
for all this.
Correct,
We
correct.
will take care of it, man.
Huh?
But let this, my lord.
So therefore, let us have some
Yes.
short dates so that we
Yes,
can
yes.
at least, this is pending since long
That's
and this
correct.
has raised many unnecessarily
It should be put at rest, my lord.
rest. Either way, either you liquidate it.
Yes.
Under IBC, give them whatever they are entitled, give a package, or you revive it.
Correct.
Be happy. Why not? You can revive it.
Once I.
But we
get-
cannot issue a mandamus. Yes,
Once I get hold of his affidavit, my lord, immediately
yes,
I
yes.
will.
But don't take it as an adversarial
My
litigation.
lord, we have not taken it.
Yes.
Our affidavit.
It's
is there.
our bank, my lord.
Yes. But
Correct.
be careful also. It should not be go to waste after investing public money for these
Excellent.
officers.
Correct.
We will examine, my lord. We have a separate branch for it. Economic Affairs Department, Finance. And so obliged.
Deeply obliged.
Yes.
May I take the-
Yes.
My lord, opposite side is absent, my lord. Here in this case, my lord, the phone number 5, who is not qualified for the post, my lord. And apprehending this, my lord,
What is the post?
my lord, Muslim marriage registrar and Kaji, my lord.
Yes.
And apprehending here, my lord, already I filed another petition. earlier.
Selection relates to which district?
On Saturday. And it was provided to follow the rule. Again, they selected this man, my lord, respond number 5 without following the rule. I have annexed this rule also.
Where is the order?
My lord, his present selection, my lord, page 36.
Now tell us, what was the challenge in the writ petition?
His selection, my lord.
His selection was under challenge.
Under
Where is the
challenge.
order? Where is the writ petition
His selection, my lord, page 36
of the writ petition?
of it.
So this was a selection made when 2020.
Yes, sir.
This was under challenge.
Under challenge.
Now what happened thereafter?
My lord, he was appointed the
Ah.
postman.
Ah.
And it was provided, my lord, in the first order that, my lord, after his appearance, his interim prayer would be considered. Then, my lord, it was provided if it is not heard, then, my lord,
Where
interim,
is that order?
my lord, this is page, I am in the IA, my lord, I am in it, page 10, my lord. Last part, my lord. However, the same will stand for consideration as and when appearance is made on behalf of respondent number 5. Then
Okay.
last order, my lord.
Now what kind of interim order do you want?
my lord, because my lord, he is not qualified, I am solely qualified, my lord.
No, now what kind of interim order you want? Tell us that.
My lord, for staying of his, my lord,
So meaning thereby to remove him from the Kazi, from who is working since 2020, where interim order is not granted.
therefore, my
That is
lord,
your prayer.
because my lord,
No, not because. That is your prayer. That a person who was appointed pursuant to a selection process,
but
when
otherwise,
this
my lord,
court has not granted interim order on 16/12/2020,
my
an
lord,
interim order should be passed in the year 2024, staying the selection and appointment. Meaning thereby he should be ousted.
otherwise, my
What
lord,
is your happiness?
otherwise,
What is your happiness in ousting him? Or do you pray in the interim that instead of him, since you are having till disposal, you should be direct, there an interim order should be issued to appoint you? How much cost for wasting 10 minutes of this court? Tell us.
otherwise, my lord, matter may be hard, my lord, entire matter.
Matter will have here, that is not an issue. We'll hear this, but how much cost for this? I tell us.
My lord, another order, page 12, my lord.
Another order,
Page 12, my lord.
page 12 of
IML. In view of the prior summit, it is provided that if on the next date of hearing, the matter cannot be fully heard, the prayer for interim relief shall be taken up for.
no, understand what kind of interim relief?
My lord, I am, my lord, actually, virtually, my lord, this lordship may be pleased to take up entire matter. This is a very short matter. My lord.
So you want to see decision early hearing petition.
Indirectly, my lord, because
So file it directly, say that this
no,
is
my
the
lord,
situation.
because earlier, my lord,
Where is the respondent number 5? We'll hear it today.
my lord, I am ready, my lord.
That's all. What is your ground?
Ground is
He is
that,
not
my lord,
having qualification.
not qualified, my lord.
Yes, who will represent this department, Kazi and all. Okay, wait for some time after admission matters are over.
My lord. Apply.
Time be. But there are not much matters, huh?
Yes.
Then we'll start hearing Mr. Chaudhary because we have heard.
Already heard my.
But give a short note what you have argued. Hmm?
And also the item number 3, Lordship.
Hmm.
2 weeks time to file a reply.
Item number?
3.
What is item number? These are not with tech matter.
No,
Huh?
Lordship. 1
No,
and
no,
2
no.
is different.
Uh-huh.
3 is separate matter. 1
Separate.
and 2 are tax together.
1 and
3
2
is
I have
separate matter altogether.
passed over.
This is who made a mention.
But I have made it mention.
What
on
is
behalf of
the-
respondent, my lord, my stay vacating application, my lord, in this case, what has happened is
Hmm.
the order of the disciplinary authority and appellate authority imposing a penalty has been stayed.
Hmm.
That stay is continuing last almost now 5 years.
Hmm.
I have filed a stay vacating application in 2020, my lord.
Hmm.
By order dated 10/5/2023, this court, on the submission of learned counsel for the petitioner, directed that instead of taking up IA separately, the main writ petition would be heard together. My lord, let the petition be heard, my lord. How many replies they're going to give, my lord? The person is going to retire in July. I can't recover anything from him, my lord. This is public money, my lord. He was found guilty of misconduct.
For the last, after the matter was fixed for file an application opposition in this. We need 1 week time to file our reply.
When affidavit was filed?
September of 2023, my lord.
Okay. We will file it tomorrow itself.
Okay, it is submitted that submitted by Mr.
Etc.
H. Agarwal, learned counsel appearing for the petitioner that the reply affidavit is being filed by tomorrow. Full stop. Mr. Ganguly, learned counsel appearing for respondent number 1 to 4 submits that order of penalty passed by the competent authority and affirmed by appellate authority has been stayed in as much as the petitioner is going to retire in the month of July. Therefore, bank is having an urgency for early hearing of this matter. considering the matter in entirety and the assurance of the learned counsel for the petitioner that affidavit is being filed by tomorrow, let this matter be listed on 4th of March 2024.
And please the earlier,
Not possible.
both of
All dates are fixed.
them.
out of March.
Some observation that it will be taken up,
Okay.
because
If the matter could not be taken up on that day, the IA Civil 1324/2020 seeking vacation of the interim order may be taken.
My lord, this is a case of departmental proceeding. The petitioner was an employee of the bank.
Mm.
On the last occasion, I had given the substance to your lordship.
Mm.
I will slightly elaborate it a bit. As I had submitted on the last occasion, my lord, in this very case, the petitioner was a recommending authority.
Mm.
Above him was a sanctioning authority.
Mm.
And further above him, further above the sanctioning authority was a controlling authority. All the three, namely the petitioner, the recommending authority, the sanctioning authority, and the controlling authority, all of them were tasked with the same office. Sum and substance absolutely same, verbatim it is same. But the punishment that has been inflicted upon them is grossly disproportionate in the sense that the petitioner has been imposed with the penalty of dismissal from service,
Mm.
coupled with the forfeiture of gratuity.
Mm.
Yes, the punishment in the case of the petitioner is dismissal
Just,
coupled with
Mr. Tiwari,
yes,
there is a matter, item number 13.
yes.
This will not take much time
Very
because
well.
this is for an order only. Whether
Very well,
we
very
call
well.
for a record,
Very well.
Mr. BM Choudhury is awaiting. So we'll
Very well,
just
very
look into whether report has come and we'll,
Very well.
okay. Because other hearing methods are
Only
almost,
the report has come, they said. Yeah.
uh,
Very well.
instead of keeping him awaiting, I think so. Will otherwise, if report has come, we'll pass the judgment only. That's all.
Understand. Perfect.
There is a report on juvenility. That's all. I see a report. না না হেতুলে কথা নেই Okay, pursuant to this court's earlier order, dated earlier order dated 12/10. Earlier order dated 16/10/2023. An inquiry report along with relevant documents has been submitted by the additional district and session judge FTC 1 Margarita Tinsukia. Tinsukia. The said a copy under seal cover. Not a juvenile in conflict of medical case. in terms of Binod Katra versus State of Uttar Pradesh. First of
medical report, my lord.
no, anyway, I will give you a copy. A copy of the report and the copy of the report as well as the relevant records be given to the Mr. B.M. Chaudhary, learned counsel for the petitioner, as well as who was appearing for union as well as who appeared for who appeared
appears for the info.
for to Mr. B.D. Kaur, learned senior counsel for the informant, and to who was the additional PP? Just a minute, we have dictated the judgment also. Just a minute. P. Thakur, learned additional public prosecutor. Full stop. List this matter on divided. Today is 12th of March as part heard. Okay. দেখুন কপির সেকশন তুমি জাস্ট নোট আনিবা যে এই পোর্শনটো এই পোর্শন দিছে হ্যাঁ ইম্পর্টেন্ট Okay, that's all we'll see. They have gone to the school, no record in the school, no birth certificate, so they did a medical ossification test in terms of so apex court judgment, and on the basis of that.
What I have, my lord, seen from
Hmm.
that age is between 40 to 50.
Ah.
That's stated.
We are good at, if you get that benefit, if it is 40, if you are, then we'll give the benefit. You are good at, that's why you are fixing it.
Apply the offer.
So, my lord, I was on the gross disparity
Mm.
in the imposition of penalty. In the case of the petitioner who was the recommending authority, the penalty being the dismissal from service, coupled with the forfeiture of gratuity in full.
Mm.
So far as the other two authorities are concerned, namely the higher authority by way of that the recommending authority. In the case of the recommending authority and in the case of a sanctioning authority,
Mm.
the penalty imposed being a reduction to a lower stage in the time scale of pay by 1 year. Reduction to a lower stage
Mm.
in the time scale of pay by 1 year.
Mm.
I will describe the entire penalty subsequently in toto.
Mm.
There are slightly, but in substance,
Mm.
this is the nature of penalty imposed on these three individuals.
And what about the sanctioning authority?
The sanctioning authority also got the similar penalty. They
Which are recommended.
reduction to a lower stage
Okay.
in the time scale of pay by 1 year. So, below, in respect of the two senior authorities, the punishment being reduction to a lower stage in the time scale of pay by 1 year. But so far as the petitioner is concerned, it is dismissal from service with forfeiture of gratuity in full. This is it. So, my lord, the issue of disparity arises from the basic fact, namely that the charge was exactly the similar in respect of the three, verbatim similar.
Mm.
Though the charge was divided into various sub-allegations,
Mm.
they call it allegations. One may argue that, well, these are the separate charges. Be that as it may, the charge is only one, but the allegations are manifold and allegations vary slightly in nature. But again, my lord, the core of the allegation remains the same. Now, what exactly, my lord, was the nature of offense that was imputed? Let me describe this. What happened was, my lord, there is KCC loan. They call it Kisan Credit Card Loan. Now, the loan is given to the farmers. Entire economy runs, my lord, on the farmers. Anyway, lots of things is done by the government. So, my lord, in order to give loan to the farmers, the system broadly is like this. Those who require the loan, they make an application. The so-called farmers, whoever they are, the farmers, they make an application. Then, my lord, that very an account is created. So, my lord, apparently they have to be an account holder. Only when they are the account holder, these farmers, then, my lord, the loan is given. The allegation is approximately 658, if I remember correctly. No. The number of loans were 968. Number of loans were 968 KCC loans. Out of the 968 loans, the allegation is the 71 loans were given to a third party. Meaning thereby, the real beneficiary, because if the account is on the name of X, instead of X,
Loan has been.
the money in fact has gone to Y. The documents are of X. The account is of X, but the loan has gone to Y. Now, my lord, if I have to prove this kind of an allegation, the best thing would be, first of all, I will identify the account holders. Who are these 71 account holders?
Mr. Counsel, take your seat.
I will identify the account holders that, look, these are the 71 account holders to whom the loan was disbursed on paper. It has not gone to them. What will I do? The first thing that I will do is, I will call each of them. Their statement will be recorded. A statement will be to the effect that, look, I did not apply for the loan. I never got the loan. So no question, I'm not the beneficiary at all. But I don't know how come my name appears. My lord, not a single account holder has been examined. The statement is not on the record. So, my lord, the very foundation, the very basis of coming to a conclusion that this money has gone to a third party, my lord, I would submit
So
that
one of
findings
the
are
ground will be a case of no evidence and perversity.
perversity.
Are you having the record?
For perversity, I have to
Are you
go
having the
into
record?
it.
Your lordship, on the last date, a direction was issued to produce the original record. Your lordship, I need some time to produce those things. Your lordship.
He could have said this earlier.
That's why, because moment it's a perversity, disproportionality or procedure, even in procedural lapses, we need the record in a departmental proceeding.
My lord, I'll put it this way. It is true, my lord, perversity, according to us, would be a substantial ground. But entire idea on the last occasion was that we argue primarily on the disparity. Because this gentleman, my lord, who has been dismissed from service with forfeiture of gratuity in full, if, my lord, because, my lord, he has already attained the age of superannuation.
No question of
So no
going
question
back.
of coming back to service. So therefore, my lord, if the punishment is reduced from dismissal to removal from service, even in that case, at least in that case, he will be getting some pension. So, my lord, we would have been satisfied with that. Though, my lord, having said this, I do admit that here is a case of perversity also.
That
But, my
will
lord, we
also
can-
require, even if we go to that,
Yes,
some
if I'm
ground
not-
to
yes, I
intervene.
understand that. But I hope I am right when I said regarding the 71 laws. Have anyone of them been examined? I have not found that. My lord, my
That
friend is
may
an
be
expert.
vital ground for
My
you.
friend is an expert.
Huh.
So far as banking transactions are concerned, he has
So
gone
when
deep
can
into
you
the
have this
matter.
record?
Your lordship,
Because there is a direction.
19th, your lordship, Monday.
Hmm?
Monday, next week, your lordship.
Mr. Tiwari, give your date. See, we don't want to go half-hearted.
Well, my lord, I get the point. The perversity would be an area, my lord would like to look into it.
Yes,
please.
yes. Otherwise, we
Ah,
cannot.
otherwise.
We cannot reappreciate. We
My lord
cannot go
reappreciate.
for
But where my lord would find,
even
there is a
no,
gross disparity.
otherwise we cannot reappreciate or cannot go for
Yes,
sufficiency.
yes,
But moment you say perversity, then we can go to the
yes.
what
No,
is
but-
the
My lord, just a minute. My lord, even without examining the aspect of perversity, if my lord finds that the allegations are same in respect of all the three, but they have been visited with a penalty, which is highly, my lord, unfair in the sense there is a gross disparity.
no, we can go on that. But problem is that suppose in after hearing for half an hour or 45 minutes, we again think that the record is required. Again, this 45 minutes.
But
There
my
is
lord,
a probability, is
that
not
is
it?
true, that is very true, but also, my lord, to appreciate the factum of disparity,
Mm.
my lord will have to go deep into the facts about the nature of allegations made and the nature of evidence that has come out.
And they will most probably argue the individual role.
Yes, naturally, they will have to argue.
They will argue the
So
individual
therefore,
role. So
diversity would
therefore,
be an aspect
as-
I have to touch upon.
yes, I
have
think
to
so.
touch upon.
So when?
By 19th, I can
Uh,
produce,
uh,
my lord, next week.
My lord, just a minute.
19th of February.
19th February. Very, yes.
Monday, 20 तारीख.
20th, my lord, will be a problem. My lord, in that
Huh?
case, could it be,
26.
my lord, to be on safer side, could it be on 26th or 27th? 26th or 27th of February?
26th.
Or else, my lord, March also it can
Or-
be, my lord.
Mm.
March also it can be 2nd of March. No, 2nd is Saturday.
Huh.
5th of March.
5th. Hmm. We'll give a try on 5th of March.
Very well.
5th of March.
No, my lord, let it be, to be on safer side, 7th of March in that case.
7th
7th of March,
is it? Okay, 7th of
7th of.
7th of March. Uh, this matter pertains to. No. You are Mr. Buragoy.
H. Burang.
H. Buragoy, learned counsel representing the bank submits that though there was a though a direction was passed, a direction was issued by this court under its order dated 19/1/2024 to produce the original record pertaining to the departmental proceeding. However, uh, he could not, he is not in a position to produce the same and will be ready with the record on 7th of March 2024. In view of such submission, matter stands adjourned and be listed on 7th of March. Mr. Tiwari has expressed urgency as the petitioner has been dismissed from service and he has not received any retirement benefit under the order of penalty.
Obliged.
Here too.
May I please, your lordship?
Yes.
Lordship, on the last occasion, our
Ah.
names were not reflected.
Ah.
Lordship, if the petitioners may be directed to furnish us sufficient copies of the petition. Because earlier, the government councils used to appear in this matter.
So,
Lordship, if we do not have any copies.
so
of-
we have asked to record your name, is not it?
Yes, yes, ma'am.
Okay. But last occasion also none appears. That is the difficulty.
Oh.
That's why we thought,
Lordship.
no, NC Das was there.
Yes,
NC Das
yes,
was
ma'am.
there.
Yes, ma'am.
Ha. Okay, wait for some time. Call Mr. A Das, not NC Das. Or what was her name? Arnav
Das.
or her and the lady, what was her name? Wait for some time.
Got
That is the issue, only a amount.
Ma'am, please, the matter.
35 and where is 35 and 36? Please, I'll put you on the order of immunity. What is this?
Your Lordship, the matter relates to the promotion of the assistant audit officers to the cadre of audit officers. Now,
Okay.
there is a stay operating since 2019, Your Lordship. Now, APSSC has also intended to advertise the post. Now, in that case, the interim order operates, we cannot be appointed. The issue is like this, Your Lordship. There is a rule which governs the service conditions of the person. And the issue relates to the promotion of the assistant audit officers to the cadre of audit officers. And as per the rule, we have to appear in the examinations. There are 8 papers. So ones who clears the examinations are entitled to be promoted. The petitioners have failed the examinations. And they have challenged it only on one count, that there was an advertisement for 32 posts. Actually, Your Lordship, there cannot be any advertisement. There has to be an intimation.
So you have been, has been directed to appoint 32%. Wow.
If you are not required to give recommendation also.
Uh.
You have to just give a list of selected candidates, qualified candidates. As under rule 17 of that particular rule. Accordingly, we have done it. We have given a list of 57% who have qualified person. From that list of it is the duty of the state government to promote that candidate.
What is the basis of, what is the criteria for this publishing, that you see who are eligible person?
There are 8 question paper as per syllabus. 8
But if every matter is time being, then we'll have to rise.
May I place Your Lordship the matters in this?
No, he's seeking accommodation for time being. Isn't it? So we are giving that accommodation. Or you say that it should not be given.
It should be given.
If he should not be given, then we'll consider, then we'll have to pass a reasoned order, whether it should be given
No,
or
no, I'm
not.
not saying that. I'm not saying that. The only anxiety is that the matter can be taken up.
Matter can be taken up 11, 15, and there is almost all matters are time being. What to do? We cannot force also, because I think there are motion matters, that's why first preference, not to the admission or hearing. Isn't it? Yes, next case. Please, hearing here. Huh? Oh. Mr. Chaudhary, start. We cannot wait, or we'll release it from part heard. Yes. He has relied on some, I think you are aware of those things, or you want to hear his argument once
In fact,
again.
I wanted to hear his argument first. Because there are 2 petitions, one regarding payment, whether he, earlier, Mr. Kumar said that he will not be pressing the first petition if the payment is made, according to whatever was decided.
You have also done your part.
Yes.
Payment was released,
Yes.
but in the meantime, the Mr. A.M. Bora's client has come, who says there is a decree in my favor. So you honored the decree by paying from that. That much.
Yes.
There was a stay.
Yes.
Here, it is Mr. Kaur is here. Mr. Kaur,
I seek the apology of this court for not being present during the first call. There was some matter.
no, that is not an issue. That is not at all an issue.
Appearing for
All. Now he want to have your arguments a little bit hard.
But then let it be a day after tomorrow for Friday, Monday.
You want to make us jobless today? We thought that this is a
You're not.
fantastic day.
Your lordship can write judgments.
Nothing is there. No pending work.
I'd like to hear from him whether he'll be pressing the first petition or he'll be fighting the second case. Because initially there was a statement that if the payment is made since he has already retired. That was what supposed to say.
That all those concessions were given subject to the result of the mediation. Now mediation failed. They are thinking.
So therefore, sum and substance, one ILR, I am pressing both the repeats. That's all.
and
We
now-
we do not want the reason.
Yes, and now if for some reason the
But,
so far all
I-
is concerned, my lord,
Hmm.
for some reason, if the termination order is set aside,
Hmm.
then I'll not be able to rejoin my duties. Only the notionally I may get the benefit, and that also, my lord, I have to look into that. If I'm reinstated in service, then whether I will be getting
Now,
paid for those.
Tell us what to do today.
Today, my lord, I was.
We will also, this court will also like to hear you afresh, because
Yes,
in
yes,
the
yes.
meantime, there was an adjournment, then we
And
heard
it's
long
not
back,
benefit.
we have not dictated anything, is not it, Mr. Kaur?
Yes, yes.
We
No,
have not dictated. So initially I thought today that we'll hear you and record your arguments. Then we'll proceed on the next day to have the legal things formulated.
My lord, subject to your, we'll have on Monday. I'll also come prepared
But you
again.
can have that. My board is tight. Very tight. We are taking around 7-8 meters per day so that we can dispose old matters.
I'm available, my lord, till end of February.
Tuesday and Wednesday, I will not be able.
Mostly possible that it may spill over to the next day because what I propose is first day we'll record your both
Yes.
submissions, factual and legal, whatever submission. Either we'll make it CAV or try to formulate the legal issues and relating to the facts. Maybe last part, we don't want to take it to the
My
chamber.
only concern today was in the morning that if the money is paid to me, it should not be paid in the joint account because earlier when.
No,
my
that you are
subsidiary-
enjoying. That is the anxiety of Mr. A.M. Bora.
Because that last time when it was paid in the joint
Because
account,
you might be a rich man. We do not know.
well, I have lost my job. You know, lost me a sin, the
No.
nefarious activities,
No,
not
no.
nefarious.
No, we'll go to that later on. But problem is that you don't have so much of urgency, though you are not getting money. It seems from the proceeding,
But
isn't
if
it?
your- If your lordship,
The
if your lordship applies. the
oil will not have any urgency because we are ready with the money
Yes,
whatsoever. We'll contest on the punishment. That
Yes.
we have correctly done it. Now there is stay order, whichever court gives, whatever we have decided, we'll pay.
No, no,
They have no problem. Your problem is that no, this is not the actual thing. You will have to penalty. In the midway, Mr. A.M. Bora's client is suffering.
No, say embarrass.
Either way,
I don't.
suppose we are not deciding whether she is entitled or not. That has been determined by competent court.
That will follow its own. course.
Its own course. So we will not even say, subject to what you say, suppose we allow everything. Then also we will not say that we'll may give an observation, their liberty, they should honor a decree of a competent court. So we'll not say, no, you cannot give, but you'll have to
No,
pass an
but-
execution. We'll not say anything.
No, but so far.
Will not say will not say. We'll say simply,
Not
we'll
simply, then-
decide whatever issue is before us.
Yes.
And we'll say in view of this determination, the other part is not necessary. That
And-
IA and all is not necessary.
And
That's all.
our case is that this pension and gratuity cannot be subject to any attachment order. For which they have paid.
That will not determine.
No,
That is
but-
not a subject matter. Nobody has done anything. We will not go to that.
But your lot will not, because I have filed a IA in this case not to deposit the money in the joint account, that has been stayed by.
No, that has been stated, but that is an IA. That is not a subject matter of any repetition.
No, but that was.
No, we'll hear on that, but problem is that
No,
today
second
you say-
repetition on that one,
okay, we'll
because my subsistence allowance, when it was deposited, the oil authorities will
so
inform.
second repetition we may hear Mr. Patwari or Mr. Bora, let us see. But main substantive issue is the departmental proceeding. For that, everything is state. When?
Monday, that is subject to your lordship.
Saturday?
Your lordship has already taken some measure.
One, that will not take much time.
Not on Saturday, but I'll study on Sunday and come up Monday. Sunday.
Nobody is interested on Saturday. We thought that
No, Saturday, I think.
Actually, everyone has some domestic, compulsion from that day.
but what about us?
In fact, your lordship also has.
But when you have additional vacation, you'll have to sacrifice the, Saturday.
On Monday, I'll come
and
prepared on Sunday.
that too, for
and
Mr. Kaur only.
I came-
Isn't it? For you only.
No, but I came just.
And where is Mr. Hendik? These two person.
I came just yesterday. I was traveling.
Okay,
whole
okay,
night.
give a date. Give a date. 1st of March.
Court of March,
No. It will spill over to 4th of March.
First of March, I have a application.
Saturday, Mr. Kaur.
Fifth,
The adjournment creates this problem because we are making a plan so that cases can be disposed of, these old pending cases. Already
Seven,
says,
seven.
6 or 7.
already 8 matters are there.
Some will be adjourned.
Okay.
11,
Okay. Fifth.
11. 11.
11.
Public.
Public.
But we'll do that on
Yes,
that.
sir.
See, otherwise I'll
You
release
know,
it
you have
from
seen
part.
other days I have completed more or less. I now have to again revise for the.
Okay,
benefit of
they
my-
have, we'll have to give a chance. to- They have, almost we have heard Mr. To an extent, Mr. Sharma also.
Yes.
Since they want to engage a senior counsel, we cannot. But to give him a audience, that's all.
Public.
Keep level.
5th or 7th.
And Mr. Kaur, there is another matter.
For the
Item number 3. You are filing affidavit by tomorrow.
Yes, it's ready.
Ah.
They have expressed some urgency
Ajay.
because I'm retired. July.
That's all.
Yeah.
They want that moment you go out, they will not get anything.
Yeah.
Because there is a stay.
No,
That is their anxiety. We do not know anything.
no, my, the action of increment has been stopped. That already I got by virtue of this case.
But
They
now
want-
they will, suppose your case is dismissed, they will recover it from you.
They will try,
Right.
but it will again take its course for either way.
Okay, anyway, so therefore, since they have expressed urgency.
Yes.
Yes, where is the private respondent? Name shown?
Yes, my lord.
Private respondent appears.
Appears Mr. M.S. Rothford.
No name shown.
Name shown
Hmm?
in the. The name shown.
Item number?
Mr. Rothford was there. Mr. Senior Counsel did ask was he was angry.
Senior counsel will not have. Senior counsel
Well,
is for every day.
look.
If somebody wants, he will bring a senior. If not, no, we do not know.
Even ultimately, this matter was fixed for hearing in several times. So it was parted before the Honorable Justice S. Sorana. Thereafter, my lord, it was CAP. Due to some mistake, in the petition, it was released for the parted and also that judgment cannot be pronounced.
In absence of the other side, how can we hear it? And also IA is given.
IA is given for
Okay,
after 2-3 years.
okay, let this, okay, we'll close the IA.
My lord, this matter may be fixed for, my lord,
The
Saturday.
present application is filed for an interim
I
prayer.
am not pressing this, my lord.
Okay.
That may be.
Mr. A.M. Barbuya Learned Counsel submits that pleadings are complete. Have you filed all
No, no, no.
pleadings are complete in the connected writ petition. In as much as pursuant to the selection, the respondent number 5 was also appointed. In that view of the matter, instead of taking the IA, the writ petition can be taken up for final disposal. Full stop. The matters pursuant to selection of Kazi,
MMR and Kati.
MM and
MMR and Kati.
MMR and Kazi. Full stop. The basic grievance of the petitioner is that petitioner is the
Only qualified
only qualified candidate
for the post.
for the post. However, ignoring such qualification, the respondent number 5, who is not a qualified person, has been appointed. Full stop. Considering person, considering that this matter is pending since 2020, list this matter for admission on, list the connected writ petition on for admission on March 15th of March 2024, for 15th of March 2024. Full stop.
10 day work.
That's why I said for disposal for 15th of March 2024. The writ petition likhiba in view of the order passed in IA, list this matter on 15th of March 2020. Okay, on that day we'll do it. Mr.
Okay.
In the admission column.
Keep them. Obliged.
list this matter. Why this matter has come? Item number 21. Huh? Write it. Item number 21. List this matter before any other bench without me. 20 negi. Okay. Okay. Yes. None appears for the parties on call. Yes. Who is? What are these? Anything survives? Are you here? Mr. Das, you intimate, give a copy to standing counsel, give a copy to him.
Right.
Okay. We are fixing it when?
I think the month of March, if it's okay with.
Okay.
Item 34. 34.
Okay. He is not having a copy, so give a copy, madam.
That's right, that's
Okay. Pursuant to this court's order dated so and so so and so. Learned
Sharma appearing on behalf of
Mr.
U Sharma,
U Sharma, learned counsel appearing on behalf of Mr.
Miss N Bora,
S. N. Bora, learned standing counsel
PNRD,
M. Bora,
N,
N. Bora, learned standing counsel for
PNRD department.
PNRD department. Submits that to obtain the instruction, you will require a copy of this petition. Full stop. MS M. Bora, learned counsel assisting Mr. N.C. Das, learned senior counsel, has submitted that she will furnish 2 copies of this writ petition to Mr.
U
Sharma, U. Sharma during the course of the day. Full stop. In view of the aforesaid, the matter stands adjourned today and be listed on
Okay, on 11th of March.
11th of March 2024. In the meantime, learned counsel shall obtain instruction in terms of this court's earlier order dated.
Okay, 12.
Hello, okay.
Obliged.
None appears for the parties on call. List this matter. However, in the interest of justice, matter stands adjourned and be listed after 4x. Yes, what are these?
Lordship, the matter relates to promotion of the petitioner. Lordship.
Huh.
It already declared, Lordship.
This is item
20, same person, Lordship.
21. List this matter before any other bench without me. Why this ISC goes so mid IA 994. No, MC 729. Out of the same selection.
Lordship, I am also not acquainted with the.
List it before any other bench without me. This series 21 to
20. Oblige.
yes. Yes, Mr. Das. What is the case?
After holding installation process are there. And at least you are prepared.
What to do? Nobody is there at 11:30, not a single. Yes. None appears for the petitioner on call. This is item number
24.
Hmm?
13.
প্রথমতে লেখা 20 20
24, my lord.
24. None appears for the petitioner on call. None did represent the petitioner when the matter was called on 24/4/2019. However, Mr. N.C. Das, learned senior counsel, is present representing the private respondent. Private respondents. And Mr. B. Das, learned counsel is present. Learned counsel is present for, yes. Learned counsel is present for APDCL. Accordingly, this petition stands dismissed for non-prosecution. Next case.
24, 24 by
Huh?
30.
25. Sing individually, ma'am.
25, Lordship,
Yes.
became infectious.
Okay. Mr. R. Sharma, learned counsel for the petitioner, submits that the writ petition has become infructuous. Accordingly, same stands closed, being infructuous.
Lordship, a similar prayer, item 30.
Item 30. Okay. Item 30. Okay. Then
26, 27, 28, and 29 months.
26. This also, I think, become infructuous. Let us see. We'll not say infructuous.
I am for the private respondent, my lord.
Okay. These are infructuous.
Well, maybe my-
Anyway,
my-
we'll not say. All these cases 26, 27, 28, 29
29.
will be like order passed in item number 24.
24.
Okay, NC does and all dismissed for non-prosecution. Okay.
Obliged, my lord.
On the last occasions,
Hmm.
the court was pleased to ask for detailed instruction of
What is the issue? First tell us.
Although the issue is with regards to promotion to the post of Deputy Director of Redevelopment. Promotion to the post of Deputy Director of Redevelopment.
subsequently has been selected.
Who has been selected?
the petitioner.
Now, there is a dispute with regard to the appointment of respondent number 5, the
Hmm.
private respondent,
Hmm.
whom my learned friend is representing.
Hmm.
Now, the vacancy in the case had arose.
No, no, what is your prayer? First tell us.
My prayer is for consideration, my prayer in the writ petition is for setting aside his appointment
Hmm.
and consideration of my case. to be
So now his appointment is not set aside, your case is considered.
considered.
Now your question will be whether you are entitled for the date he is from, his junior or what?
He's junior.
Anything on that?
No, that is admitted, my lord, that he's,
No, no, anything regarding that in the order?
no.
So let them consider that aspect of the matter.
But there will be a difference, probably subject to your lordship's
Huh?
approval. But
Hmm.
unless his appointment is determined as legal or illegal,
Hmm.
my claim to the post will not arise.
Why?
Because his promotion was against the promotional quota.
Hmm.
And I am a candidate against the promotional quota.
Hmm.
Now, unless this honorable court either way holds that his promotion to the post of deputy director against the quota is legal or illegal.
Hmm.
Naturally, because it is one post,
Now you have been promoted against which post?
I have that they do not say very specifically. They simply
Now,
say,
see, there can be two questions. Why should we set aside his appointment for consideration of a case or giving benefit to you? You will only be given notional benefit if at all it is given by
Yes.
from a date.
yes,
Now, how
now, if the notional promotion, now the position stands, my lord, whether I'll be entitled to seniority from the date.
So
Yes.
therefore, let that part be considered by them. Can we decide that where it is not a pleaded case that these are the, I am entitled for this?
No, that is the pleaded case. That is the pleaded case. Now, only thing is that, my lord, if your lordship would dispose of the matter on with the observation
Huh.
that the respondents will decide
Hmm.
whether or not to grant me promotion with respect from the date
Retrospective effect
Yes.
from the date when the respondent number 5 was promoted.
promoted. If that will be
Because
absolutely-
then we'll know their
Yes.
reasons.
now, but in that order, my lord, your lordship may keep this part open because otherwise I'll
No,
be
no.
by res judicata.
Yes, no, that will clear that issue relating to your entitlement. So far, the promotional benefits from the date when respondent number 5 has been given is kept open, and that can be agitated if his consideration is against the claim of the petitioner in any proceeding. That will do.
Yes.
I do not think we should exercise that at this stage.
Yes, that will do.
That will
That will do.
that will protect you.
Only thing is, my lord, they have, I mean, since the question of promotion of the respondent number 5 is involved.
Hmm.
So, my lord, next, my lord, they,
Even to the challenge to the promotion of the respondent number
Yes.
5 is also kept open.
Yes,
You will
yes.
you both are having appointment, isn't it?
if that prayer, particularly prayer number.
Or we'll go for a hearing then.
Lordship, hearing is necessary because this was a fresh appointment. Because there was a selection board, then he was selected. Then he appointed.
No, understand.
Earlier,
His claim that I am entitled for promotion from the date respondent number 5 is promoted. Anything on that?
No,
So that ought to have been, since you have promoted him, you ought to have been said that, see, you are whatever you have said, that this year promotion is by selection grade, it will take effect from this date, you will not entitled for any benefits for this good reason. Matter, that is what we want you to do.
yes.
That's all.
Therefore, my lord, as it has fallen.
That
to
will
my
be
lord,
open.
The prayer A should remain.
Yes,
open.
open.
Prayer A in the writ petition, that is,
This is good for everybody.
yes. That will give a. that
Isn't
will
it?
give a- Yes, absolutely. No, that is.
Yes, what you say?
Lordship will fix another review, Lordship, short review.
so this is appearing for respondent.
No, we are not interfering with your promotion. Isn't it? We are not interfering with your promotion. He claims something, some right. That, see, I want for appointment from such and such date. His basic fund has been given. This order is not under challenge.
No.
Saying that I have not been, though I have been given promotion, these are not there. So he want to approach you that, see, you have given me promotion, not you, him, but give me all these benefits, and for that you will have to do this.
Yes. Return.
Do this. You determine it. Let him file a representation. You decide it, because in this order there is no reflection of that.
No.
If he is aggrieved by that, then he will come. If you are aggrieved by that, you will come. That's all.
We have no objection, Lord. But my prayer will be, Lord, may keep the open up for limitation because this appointment was made in 2030. The appropriation was put in 2018.
No, everything, I want everything should remain
Everything
open.
should be open.
Everything should, I am not saying that.
Even challenge to the promotion of respondent number 5, that on the ground of delay,
Yes, yes.
we also open,
Let everything remain open.
since one part is given.
So Lord, you can fix another date, Lord.
For that,
Maybe
why?
let us take instruction, Lord.
Okay, it is submitted that during pendency of this writ petition, the petitioner has been promoted to the post of what is called
Deputy Director
Deputy Director
of Tea Development.
of Tea Development under Tea Board,
100%.
under the Tea Board. However, his claim is that he ought to have been promoted in place of respondent number 5. And therefore, the petitioner claims that the benefit of promotion ought to have been given with effect from the date of promotion of the respondent number 5. However, the order of promotion is silent about the same. Mr. S. Datta, learned senior counsel, while arguing that the promotion of the respondent number 5 was out and out illegal, and in his place, the petitioner ought to have been promoted. However, since a promotion has been made, it is now the bounden duty of the respondents to give the benefit of such promotion from the date when the respondent number 5 was promoted, even by nullifying his promotion if so advised. He further submits that such issue has been pleaded in this writ petition. However, as while passing the office issuing the office memorandum dated 19/12/2023, no determination had made in this regard. The petitioner may be granted a liberty to approach the authority raising all the issues that has been raised in this present writ petition, including the legality of the promotion of the petitioner, so that a rejoin order, so that the respondents can pass a rejoin order in this regard and give a fresh look in this regard. Full stop. Responding to such argument, Mr. Gautam, learned counsel representing the respondent number 5, submits that he may be granted some time to obtain instruction in this regard from his client. Mr. S.C. Kyle, learned counsel, however, submits that he will no objection if the matter is remanded back to the authorities. However, the issue of delay and laches of the petitioner in approaching this court by filing the present writ petition and challenging the promotion of the respondent number 5 should also be kept open. Full stop. Be that as it may, as Mr. Gautam has sought for an adjournment, prayer stands allowed. List this matter on 19th of March. A copy of the order, not necessary. That much, if you agree or will hear.
Well, that would be the best thing.
I think that
It
will
will
be the
serve
best.
everyone's interest.
Future also it will serve everyone's interest. Is that it, Mr. Kyle?
He is every time he is benefited.
Yes.
Ultimate.
This time also will be benefited.
This time also.
Yes, next.
Obliged.
It's dismissal from service.
Who is representing the petitioner?
My lord, petitioner A.
AK Sharma means which AK? He's having some health issues.
I'll take it step by I'll take it step.
Your pleadings are ready.
Yes, my bidding is ready.
Long, this was a remove from service.
Let's
None appears for the petitioner on call. Though MS A. Gayan Learned CGC is present representing the Union of India. This matters pertains to removal of this matters pertains to removal from service with effect from 13/6/2016, which was affirmed by the Deputy Inspector General. Not necessary, please. Second inquiry, that is the ground, I think.
Yes, ma'am.
Huh?
Yes, ma'am.
Well, after 1 second, whether that is permissible, that's all.
Yes,
If
ma'am.
permissible, permissible, if not, if not. However, in the interest of justice, matter stands adjourned and be listed after 3 weeks. Last. যেটা কি আছে hearing কিন্তু 33 মাতাসন yes duty
In this case, Your Lordship, I was absent from my duties. As such, finally, I was removed from service. Challenging the inquiry report, the order of punishment,
some police or armed
CIS,
forces.
Central Industrial Security Program. I was working as a constable. Your Lordship, may kindly peruse.
Okay, we'll come back. You are ready?
Yes, sir.
Ready? We'll come back. And what is the other method?
My lord, that is possible for the Mr. Architect today he is out of state.
Okay, it is what is the issue here?
But the dismissal for 30.
Okay. This is a dismissal for service bench or what? It is submitted that Mr. R.K. De Chaudhary Learned DSG is out of station and accordingly a prayer for adjournment on his behalf is made by MS A. Gayan Learned CGC. Prayer stands allowed. Please this matter
Yes, sir.
after 2 weeks. After 2 weeks.
Date may be fixed.
Okay, give a date, mostly whenever after 2 weeks or 3 weeks. Okay,
Yes, sir.
we'll come back. How many methods are there? Yes. Yes, Devi.
The Lordship, in this case, an inquiry was conducted against me ex parte. Thereafter, I was declared a fugitive and I was removed from service. Your Lordship may kindly peruse the inquiry report, which is at page
What is the search?
29.
Yes.
Charge is also there in the inquiry report at page 31. Your Lordship. May I read it? In In pursuance to the order of the so and so, sir, I'm reading the charge, you know, the particular charge. CISF number so and so, Saurabh Roy was deployed in Exari outpost line of CISF unit on dated 8/7/2015 in sea shift duty from 2011 to 600 hours, but he deserted his duty post and went to his home village Daligaon, post office Pamakhata, police station Patatakusi, district Borpeta, Assam, pin code 781325 without any permission from any competent authority. As informed by ASI, SN Singh, Post Commander and Inspector EXC MD Irfan Roy, Commander B Company, after contacting him on his mobile as on 7/7/2015, about 18:10 hours. After that, this office had sent 4 call-up letter to CISF number Saurabh Roy on his home address, but neither he appeared for duty nor he intimated anything regarding this. Apart from this, CISF Saurabh Roy was given a message to CISF unit IOCL Bongaigaon by special messenger for reporting him in the unit, but even though he did not return back to the unit for duty, being a disciplined member of the armed force CISF, Saurabh Roy deserted his duty place without any information permission from the competent authority. So the above act on the part of CISF Saurabh Roy tantamount to gross indiscipline, misconduct, dereliction of duty, and unbecoming member of the armed force. Hence the charge. Then your lordship may kindly peruse page 32. This is the statement of the witnesses. PW 1.
Page?
Page 32. Your lordship. List of statements of PW 1. List of statements of PW. May I read your lordship? During the course of inquiry, 4 PWs and 1 CW were examined and cross-examined by PO. As charge officer did not attend the inquiry, so re-examination cannot be done and defense statement of charge officer cannot be recorded. The list of the statement is separated below. I'm reading 33 years, 34. He is the only person, according to allegation, he is the only person who was contacted by me. This is P.P. Gogoi, your lordship, constable, ground duty constable, P.P. Gogoi, page 34, your lordship.
Page?
34.
Hmm.
PW Force CISF number so and so, constable ground duty P.P. Gogoi of CISF unit, case
Page 34.
page 34. Top
PW4.
PW4. Stated that on dated 7/7/2015, stated that on dated 7/7/2015, he was detailed at line duty in Aksdaik outpost from 1300 hours to 2000 hours. CT Saurabh Roy at about 16 hours informed him that he is going to Exari Bazar for mobile research. As per duty development research, CT Saurabh Roy was detailed in A+C shift at line duty in Aksdaik outpost, and Saurabh Roy had performed A shift duty at line. At about 1850 hours, he received a mobile call from CT Saurabh Roy. The Saurabh received a telephonic message from hometown that his mother was ill, and he left for hometown. At present, he was missing. Sahibang railway station. He asked him whether he was joking or really going to Assam. CT Saurabh Roy replied that he was honestly telling that he is going to home, and at present he was in Sahibang railway station. Requested CT P.P. Gogoi to inform the matter to Post Commander. CT Gogoi immediately informed the matter to Post Commander SN Singh, who thus reached the outpost after completion of the day shift patrolling duty. Post Commander also talked to Saurabh Roy over my mobile. Saurabh Roy replied the same thing to Post Commander. Then AC SN Singh sir request him to return back to line and go home after taking leave, but Saurabh did not return back and continue his journey. SN Singh sir informed the matter to Company Commander and C-Roop. On questioning by PO about CT Saurabh Roy nature, he replied that he had done basic
Now,
training.
what are your grounds of challenge?
Your lordship, in this case, the ground is there was an ex parte inquiry. I should have been given an opportunity. I have not received the notices as they have directed. However, your lordship, the next part that I want to submit is the proportionality, the punishment, your lordship. I have been removed from service, your lordship may kindly peruse the order. I'm only reading page 47. This is the order, the final order, relevant part,
Yes.
page 47, para 5 onward.
down below your page 47.
Yes.
After closely examining all documents related to the procedure file and the statements recorded by the prosecution side during the department inquiry, has come to this conclusion that the allegation against the accused are fully true because all the statements of the prosecution side have been found in one queue and the prosecution side produced enough witness to prove the matter. On the other hand, the accused constable, in spite of giving several call letters to place his defense against the allegation, did not turn up physically. He even did not write anything or send any document on behalf of his defense. Therefore, I, the undersigned, utilizing Rule 31 of CISF Regulation Act 2001, hereby pass the punishment order of removal from service against force number so-and-so Constable Saurabh Roy of CISF unit on KHSCPP Kohalgaon after all allegations against him be giving in proof. Him. The force number Constable 3B Saurabh Roy's regular action will be dealt with by the leave action of the CISF unit from the date of his principal on 7th, 2015 from the date of declaration of the fine. Against that, Your Lordship, I filed an appeal. The appeal also was disposed of on 5/5/2016, 53.
Where is that?
The page starts from page 53, Your Lordship. Relevant portion is that page. Page 53, Your Lordship. I want to peruse page 55, Your Lordship. May kindly peruse. Paragraph 3. The inquiry officer completed all the actions required for departmental inquiry within the expected time and rule and regulations. The petitioner was given enough time to present in the process of departmental inquiry and send notice to his home address, but the petitioner did not present in the departmental inquiry, neither he gave any information. I dispute that, Your Lordship. Therefore, the inquiry officer completed the one-sided departmental inquiry following all departmental norms on the basis of the witness statements and procedure file records, justified the imposed allegation. After completed departmental inquiry, the inquiry officer or going to handed over the procedure file to inquiry report district officer. Then Your Lordship may peruse page 57. Page 57 is the order, the operative part. Paragraph 5, Your Lordship. After minutely studying and analyzing the procedure file and petitioner's appeal petition, it has been found that this department procedure, the inquiry officer under the inquiry procedure as per CISF rules and regulations, where there is no any discipline, the act of the petitioner is not accepted in the view of discipline measure. Therefore, the order passed by the discipline officer against the petitioner has been found thus and appropriate. There is no scope to interpret the judge. This was done. Then Your Lordship, a review was also done, and the review order is at page 64, 3/8/2016. Page 65 is the operative part, Your Lordship. From down below, fourth line. Fifth line. From down below. Being a responsible.
Just a minute. No case.
Your Lordship, I am only on the quantum of, I understand, Your Lordship, only on the quantum, Your Lordship, may kindly use air 2004, Supreme Court 213.
What can be alternative punishment in a discipline force?
My family is dependent upon me, Your Lordship. They're
Huh?
getting backup and-
Removal, they have not dismissed you from service. You can still be appointed in other, isn't it?
Reduction
Removal
in-
will give you that benefit. Dismissal would not have.
May I respectfully pray, Your Lordship, if reduction in rank can be done, at least, a reduction in rank will at least be allow me to survive. Your Lordship. Reduction in rank, that is my only respectful submission.
No case.
Right.
You are very lenient, but this is not the case. Heard Mr. Theory, learned counsel for the petitioner. Also heard Mr.
Yes, law.
P.S. Law. Law Court, learned CJS. The present application is filed assailing three orders. Firstly, order dated 29/12/2015, whereby a departmental proceeding was initiated against the petitioner. Whereby a punishment of removal from service was inflicted upon the petitioner. Petitioner. The second challenge is the inquiry report dated 23/11/2015 and third challenge is the order dated third order is the order dated 5/5/2016 passed by the appellate authority rejecting the claim of the petitioner. The further order is the challenge. The further challenge is to the order dated order of order dated. What is the revisional order? 14/8.
To third,
14/8/2015.
yes,
Or an order
T8,
passed by the revisional authorities. Full stop.
T8,
Huh?
T8.
3/8.
3A to the
Okay.
6.
The brief fact leading to the present case can be summarized as follows. While the petitioner was serving as Constable CISF and was posted at Eksari Outpost. Where is this?
Your Lordship, Bihar,
Eksari Outpost, Bihar,
district Bhagal,
in the district of Eksari Outpost in the district of Bhagalpur, Bihar. Alleging that the petitioner has left the duty without any intimation and inquiry was conducted. Full stop. The conducted. And a charge was framed under Rule 36 of the CISF Rules 2001 by a SARS memorandum dated 14/8/2015. by the commanded CISF unit K capital small h, then all capital continuous of STPP within bracket K. The surge is quoted herein below. Page 31, pencil mark to pencil mark. Okay. Thereafter, it is the allegation of the employer that even after issuance of many communications, the petitioner neither returned and rejoined his duties nor filed any reply to such surge, and accordingly an inquiry was conducted. Full stop. The inquiry was conducted ex parte. Full stop. The as many as four witnesses, four prosecution witnesses and one court witnesses were examined in proof of the surge leveled. Full stop. After completion of the departmental proceeding, comma, by order dated, where is that order? Inflictment of punishment?
Page 42, Your Honor.
By an order dated
29.
29/12/2015, a punishment of punishment of removal from service under Rule 32 within bracket 1 of CISF Regulation 2001 was inflicted upon the petitioner. Full stop. Being aggrieved, the petitioner preferred an appeal under the CISF rule. CISF rule. Such appeal was disposed of by an order dated 5/5/2016 by the appellate authority and dismissed such appeal. Full stop. Next. Thereafter, the petitioner approached the revisional authority by preferring a revision, and such revision was also dismissed by the competent authority under its order dated 3/8/2016. Full stop. Being aggrieved, the present petition is filed. Mr. Deori, learned counsel for the petitioner assailing the orders, argues that there is absolute violations of the principles of natural justice, inasmuch as the notices were not duly served upon the petitioner, and therefore he could not reply to such charges, and therefore the petition is therefore this court may, in exercise of its power, shall set aside the entire disciplinary proceeding and be pleased to ask the department to initiate a de novo proceeding by giving reasonable opportunity of hearing in terms of the CISF rule to the petition. Full stop. Mr. Deori further contends that though it is an admitted position that petitioner left for his residence, however, the evidence of the witnesses shall clearly reveal that the petitioner had to leave the station for his hometown in an extraordinary situation when his mother was ill and he informed his fellow colleague, informed his colleague, though he did not inform his higher authorities. However, in view of such emergent nature, it cannot be said that such action on the part of the such unauthorized absent is willful. Full stop. Willful. Next. Willful, and therefore, the decision is liable to be interfered with. Full stop. Mr. Deuri further contends that in the aforesaid factual backdrop and his mother illness, and inasmuch as in view of the established situation that the petitioner had to live in an emergent situation, the punishment proposed is disproportionate, and a lesser punishment of reduction. What is the next reduction?
Reduction in rank.
Reduction on rank would have the option with the respondents. Full stop. Accordingly, Mr. Deuri submits that even if this court is not inclined to interfere with the decision or the decision-making process, this court may direct the authorities to reconsider the quantum of punishment. Per contra, Mr. Locker, learned CGSC, appearing for the Union of India and relying on its affidavit, argues that the petitioner is a member of a disciplined force. Therefore, the authority cannot take a lenient view, inasmuch as it is an admitted position that the petitioner has left his place of place of posting without intimating his higher authorities. Full stop. Even in the case of emergency, the petitioner could have make an application for grant of leave before the competent higher authorities. Full stop. Referring to different documents annexed with the affidavit, Mr. Locker further contends that the notices were duly served upon the petitioner, argues that recalling back the petitioner to his unit, notices recalling the petitioner to the unit were duly served upon the petitioner through the local police station. However, in spite of such notices, the petitioner did not resign his office. Thereafter, also the search memos were duly served in the residence of the petitioner, which was duly accepted by the mother of the petitioner, and therefore it cannot be said that petitioner has not been given any opportunity to contest the proceeding. Full stop. In that view of the matter, there is no violations of the principles of natural justice. Full stop. Even after non-appearance of the petitioner, the authorities has proceeded in terms of the rule and examine witnesses. Accordingly, Mr. Locker submits that this is not a fit case to interfere or to be interfered with. Full stop. I have given anxious considerations to the arguments advanced by the learned counsel for the parties. Peruse the material available on record. Full stop. An affidavit has been filed by the respondent union with certain documents. Which documents? No reply affidavit has been filed.
I have filed.
Where is that?
I had filed it on 23rd January 2023.
Give a copy, but that is not here. Okay, not necessary. File by file. No, not necessary. That is necessary. Not file reply is not necessary. Okay. Okay. Full stop. Are you having the record? No. Okay. Mm. Full stop. Okay. Okay. Law is by now well settled that the constitutional courts, while exercising its jurisdiction while exercising its power of judicial review under Article 226 of Constitution of India, dealing with a departmental proceeding, would not generally interfere with finding of facts arrived at in such departmental proceeding, except in cases of mala fide or perversity. The mala fide or perversity. The Constitutional Court can also exercise power of judicial review when there is violation of procedure mandated for conduct of such departmental proceeding, resulting in violations of principle of natural justice. The power of judicial review is meant to ensure that an individual receives fair treatment. However, such power of judicial review is not to judge the conclusion arrived at by the authority and to verify whether the same is correct or not. This court, in exercise of such power of judicial review, do not act as an appellate authority to reappreciate the evidence or to arrive at its own finding. Okay. In the aforesaid, in the backdrop of aforesaid settled proposition of law, let this court consider the present case. The fundamental, the principal ground for challenging the decision is the violations of principles of natural justice. Full stop. From the record, it is seen that on 9/7/2015, a call-up letter was issued by Assistant Commandant CISF Unit KHSTPP, Assistant Commandant of the CISF Unit where the petitioner was, under whom the petitioner was posted. Such communication was, the aforesaid communication reveals that the it was addressed to address it was addressed to the petitioner, and a copy was marked to the local officer in charge, local police station, with a request to serve such copies and report thereafter. Full stop. Such communicates, the record further reveals that the record further reflects that.
See call up notice.
Hmm?
It's see call up notice.
No,
to
no,
receive
no, no,
the-
we'll go to, it will go to that. The report further reveals that such notice was served upon the petitioner by the officer in charge, Patsala outpost, and accordingly, a report was submitted before the authority. Report was submitted before the authority, before the CISF, by the officer in charge, Patsala police station. Full stop. Such the communication and slash document was exhibited in the departmental proceeding as Exhibit 1 by PW3. Good, sir. Subsequently, similar notices were issued on 16/7/2015, and a report was submitted by the officer in charge on 29/7/2015, which was also exhibited as Exhibit number 2 by PW3. Full stop. Thereafter, yet another call-up notice was issued on 22/7/2015, same was served upon the petitioner on 11/8/2015, and report was submitted to the commandant of the unit, and the same was also exhibited as document 4 by the PW3 in the departmental proceeding. Thereafter, a communication dated 30/7/2015 was issued to the Superintendent of Police, District Barpeta, Assam, under whose in which district the petitioner is a resident, along with a copy of the charge memo. Isn't that it? The charge memo was by
Along with inquiry note.
Huh?
Along with inquiry note.
Along with an inquiry notice to the petitioner. Full stop. Such notice was received by the petitioner on 11/8/2015, and a report was accordingly submitted, and such report was also exhibited before the departmental proceeding. Full stop. The inquiry notice thereafter, the inquiry notice dated 1/10/2015 was also sent to the petitioner. The same was received by the mother of the petitioner, and on the thumb impression was put therein. Full stop. Therein. Thereafter, a preliminary hearing notice dated 8/10/2015 was also served at the residence of the petitioner, which was duly received by the mother of the petitioner on 22/10/2015. Similar is the case dated inquiry notice dated 28/10/2015, 4/11/2015, 4/11/2015. Full stop. The inquiry report was also served upon the petitioner on 13/2015, which was duly receipt of which was duly acknowledged by the petitioner. Full stop. By the petitioner. By the petitioner. though and reply affidavit has been filed, an attempt is made to defend the stand of the petitioner regarding non-supply of document, etc. However, there is no specific denial that the petitioner that aforesaid documents were not duly served as stated herein above. Full stop. In view of the aforesaid, this court is of the unhesitant view that the petitioner had opted not to contest the departmental proceeding on its own and due notices were served upon him. Coming to the basic fundamental allegation of unauthorized absence, the petitioner has not denied such absence. However, he is trying to give a reason for such unauthorized absence. Full stop. This court, as discussed herein above, cannot consider such a defense in a proceeding of judicial review, more so when the petitioner had not contested and disputed in the departmental proceeding or raised such an objection that unauthorized absence was not willful and deliberate. Not willful and deliberate. Full stop. That being the position, this court finds no merit. Coming to the proportionality of the departmental proceeding, law is well settled that so far relating to the discipline forces like CISF and armed forces and relating to unauthorized absence, there should not be any lenient view. And when a person, when a member of a discipline force even did not bother to intimate his employer regarding his alleged mother's serious illness, this court is of the view that the punishment cannot be said to be disproportionate. Accordingly, the present petition stands dismissed. Parties to bear their own cost.
Briefly, okay.
That letter is only the letter has been sent. Also, that is to letter to the superintendent of police.
To the police.
That is not
Not, no, that I have seen that. Subsequent. Correct.
All right.
3 more days to get it online because you'll have to correct it. Instead of hoping after 5 years, hope is over. Now you can be busy with your search for job.
Briefly.
Yes. What is this? Why amicus? Any amicus appointed?
No, Your Lordship.
Last order is as spread on behalf of the learned amicus who released this matter on
Might have been wrongly recorded.
Yes, madam.
Lordship, there's no amicus curiae.
Okay, forget about that. Now, who is for the petitioner?
I'm for the petition.
Yes, tell us.
Lordship, kindly a dating fix the Lordship.
Why?
My senior, Mr. Kane, appearing this and his report.
So far we recall it, there was an understanding on a last occasion that
There was
nothing survives. If that is a select, only a list, if you have not qualified. That was the understanding, I think, on a oral, if I
Yes,
can,
yes,
if I
absolutely
can
right.
recall.
Absolutely right, Your Lordship. It's an interdepartmental promotion examination. The conditions are like that. One has to qualify in the examination. Only
Saturday.
then.
Saturday.
Saturday.
Hmm.
Lordship, can it be on Friday?
Kali na ho pate. Saturday.
Saturday is a fine day, your senior can argue also. You have enough time, we have only fixed 2 matters.
Lordship,
Otherwise,
can
you can
be-
start with Saturday.
Lordship, can be on Friday or
Friday, not possible.
then Monday or
Not possible. Friday?
Special TV.
Tomorrow? Tomorrow is Friday.
Okay.
See, we don't have any problem if Mr. Chaudhary wants to argue on merit, that is, but we want preliminary whether their stand is correct, that there is a list of qualified person, you were not qualified at that point of. If that be so, why should stay be continued? Is not it? If you have a case, of course,
Your lordship.
oh, no problem on that. We'll hear them. If they still says, this is your preliminary thing, that there is a list, it's not in fact a selection, on the basis of a selection that has been given, these are the qualified person, nothing more, nothing less. And they have not come within the zone of consideration, or they are not qualified.
In fact, they have not challenged the merit list of. They have challenged only the communication.
So that's all. Don't expect to come back at 2 without any method.
Let it be on 23rd, next
Tw-
Friday.
Next Friday,
Not
23rd,
50 rupees.
23rd. As agreed to with the Landes County. Just have that instruction. If you want to argue on merit, of course, we'll hear him. Maybe we adjourn on Friday also, no problem on that. If there is a contentious issues are there, I have no problem hearing this. But if whatever they say, if that is the correct, why should we waste our judicial time? That's all. Hmm. They say this is not an advertisement. This is a,
An advertisement, it is there on record.
what is the qualification for advertisement? What is the qualification for the next promotion?
Next promotion is
Are we
to qualify in the exam.
Okay. What is the
And
post?
our
What are the posts?
Post is the audit officer. We are
Audit officer. What is the feeder cadre?
assistant.
You are assistant officer. You are seeking promotion to the audit officer.
Yes,
What is the qualification?
to qualify in the examination.
Qualifying in the examination, whether you have qualified.
No, Lord.
So
We
if
are
you are
the
not,
exempted candidate,
Huh?
Lordship. We are the exempted candidate.
what is the exempted candidate?
Exemption means, Lordship, suppose there are 10 papers, Lordship.
Mm.
We have clarified out of 10, Lordship, we have clarified 5 papers, Lordship.
Mm.
Then, Lordship, in the next year, Lordship, we need not participate.
Okay, we'll have the 5.
Yes,
Next
Lordship.
5 you will give.
Yes,
Out of 10, 5 you have qualified this year, next 5 you will qualify in the next year.
Next year, Lordship.
Okay.
Now, Lordship, for this particular year, 32 posts were advertised.
Mm.
We are saying that, Lordship, no appointment beyond 30.
So you want to say that until we pass it,
At least.
until we pass it, don't fill up.
Yes.
Who are you to say that? You fail in the first exam.
May I put it in other ways?
Yes, put it in other way.
Lordship, in the advertisement, clear mention is about 32.
Okay, let us see the advertisement.
Yes. Page.
Let us see the advertisement. Let us understand for Friday.
Yes, sir.
Where is the advertisement?
Page 20. your
Page
lordship.
number 20, Lordship.
20?
20. First paragraph.
Okay, so this is a 32 post,
32.
Now?
Now, Lordship, kindly come to page number 21.
21.
This
And
is the
so-
breakup of post, Lordship, STP2,
Mm.
STH4,
Mm.
SC NEET,
Mm.
total 30.
Okay.
Now, Lordship, our basic difference is that, Lordship,
Have you passed, completed the exam, passed the examination in the meantime?
No.
Then till, suppose, till according to you, till what time they should wait for you? Not to fill up subsequent vacancies.
even Lordship, they may issue fresh advertisement by tomorrow itself, Lordship.
No, what is your right to, you cannot even participate.
We can participate.
How?
In the next exam, Lordship, we will get chance to sit in that.
In the next exam, you will get to chance for the rest of the post.
That is our.
And who are the private
Your
respondents?
lordship, may I just clarify one
Ah.
thing, your lordship.
Ah.
Your lordship will see the manner in which they have drafted the entire issue they have taken.
Hmm.
Your lordship, the examination was conducted on,
Hmm.
the notice was on 3rd of May 2018.
Hmm.
That is annexure 1.
Hmm.
The exams were over by 28th of January.
Hmm.
That is at page
No, just tell us one thing, what I could understand, today we are not deciding
Yes,
it.
Your Lordship.
What I could understand from his argument is this.
Yes.
That a qualification required is passing an examination.
Correct, Your Lordship.
We have an option of have two or three, how many times you can appear? Two,
Uh,
There is no.
innumerable.
okay, innumerable. So in this year, there are 32 earmark vacancies. What is his argument? We
Yes.
are not expressing our view.
Yes.
What is his argument is 32 vacancies earmark. This may not be an advertisement, but this is the 32 vacancies.
Yes.
So persons in merit,
Hmm.
top 32 persons will be promoted to this.
Right.
So accordingly, you send they held the examination.
Yes.
So 50 persons passed this exam, 56 or something like that.
57.
57.
Right.
Now, out of 57, their case is that why should we appoint beyond 32?
Exactly.
Because if you held the next question, because your earmark vacancy is 32, if you held the question this year, if we pass, those vacancies, our cases will also be considered.
Yes.
Is that it?
Yes.
So therefore, you cannot give appointment to those persons. They should once again compete with us. We may get more marks this year.
No. Let me come up with. First of all, Your Lordship, one is to pass the exam. We have passed the exams. There is no denying about that.
No, that we understand.
No,
But
no.
suppose in your luck there is no earmark vacancy. Why should
No.
you eat up his vacancy?
No. There is earmark vacancy. Your Lordship will kindly look on the exams.
Okay,
examination
place this matter on.
tomorrow, Your Lordship.
Mr. Gordon has clearly, he has clearly there.
What is just then?
Parur advertises is not a precondition for selection of candidates for this position. Either relevant to require to declare number of vacancies.
Ah.
The advertisement was made only for information about the selection process.
No, forget about the advertisement. We are not on advertisement. What was the vacancy on that day?
53, Your Lordship.
That government will have to say that this was the 53
In
vacancies.
fact, from their own document, it is clear, Your Lordship.
The government will, if government can satisfy us that forget about this advertisement, on that day year, there were 53 vacancies and for examination was held, this 53 person has passed, they will get a promotion. We will not wait for those person who failed. Until and unless you say that these are the 53 vacancies, that's all.
Your Lordship, on
Tomorrow.
28th of that.
Now Friday.
Tomorrow, Your Lordship. Tomorrow, Your Lordship.
Huh?
Tomorrow, Your Lordship. Otherwise, APC will advertise the post again, Your Lordship.
That is another.
নালাগে কালি থাকিব স্যাটারডে স্যার না থাকে স্যাটারডে স্যার না
Next
থাকে
Friday, Lord.
Who is-
তুমি আর্গুমেন্ট করিবা যদি
Who is assisting Ken Chaudhary?
I'm,
Please.
I'm
Next Friday?
next Friday.
Okay, next Friday, 23rd.
And more or less, Lordship, that is the issue.
Understand? If they say that if rule says that this advertisement word is having no relevance.
Yes. And
Number
vacancy
one.
was 33.
Number two, that these are the earmark vacancies arose for this year. Exam was held. Serially on merit we have given. Why should we interfere for those person who has failed in the examination?
In fact,
Yeah,
that is
that's
the
And
that is the
but
practice.
if they can show, if you can show, or we are satisfied that earmark vacancies is only 32, then of course you will have a right, because you can again you have a rule permits you to appear in the next
Yes,
year's
sir.
examination. That will see.
That is our.
That is the issue.
That is
Why
the
you
issue.
take adjournment for these all these issues we do not need.
That is the.
That's all for today. See, Pujari, we are now jobless. Nobody is interested in cases. What should we do? Now we'll ask for the part 2 list, and if nobody is there, we'll dismiss it for today. See, not even one. How will you answer our conscience? And no, nothing to be dictated also.